Good morning. This is the Bastrop County Court at Law, February 22nd, 2021. The court will call cause number 2020107 in the interest of Flores children. This is the purpose of a status hearing to address the upcoming procedures and admissibility of evidence and general procedures of including how long the trial will last. Ms. Barrera, or do you represent the original petitioner?
Can you hear me, Judge?
Yes, now I can.
Yes, Your Honor.
Okay. And Ms. Salazar, you represent, I guess you filed an answer and a counterclaim as well?
Yes, Your Honor.
Okay. Has all the discovery been completed?
I think the parties are pretty much in agreement to maintain temporary orders. I think there may be two issues that we need to move forward on. The parties are so polar that we felt like mediation would be a waste of the parties' monies. And we wanted to move straight forward to a final.
Okay, well, you can do that if you don't want longer than 2 hours. If you want longer than 2 hours, then you have to go to mediation.
And Your Honor, I think the issue is that we'll need a translator for both of our clients. So we just think it'll take longer, even if normally it would take 2 hours. I think with the translator, it'll take up to 3.
Okay, what are the contested issues?
It appears that mother is dating a registered sex offender, and there are 2 minor children subject of this suit. At temp orders, we agreed to a restriction so that the man could not be around the children. Mother would like to lift that restriction.
Okay, and is that the only issue?
There's that issue, Your Honor, and I believe, at least from my client's perspective, the issue of child support.
Okay, Ms. Barrera, where does your client work?
Where does my client work?
Yes, or how does he earn a living, so that if we are going to assess child support, how do we, is it just a simple, straight up?
It's a little bit more complicated. When the pandemic, he was working for the University of Texas part-time. When the pandemic hit, he lost his job. So he's working sort of odd jobs. And we do have child support in place right now. So the children are being supported. I didn't realize that child support was going to be an issue, but we can have that documentation for opposing counsel.
What I would like for you to do is to have all of your documents to the other side at least 7 days prior to trial, whenever we do set that. And
Yes, sir.
then and a request to stipulate to the admissibility of the documents, reserving only those things that are legitimately in dispute for the trial, marked and to the other side, and then back, and then with responses to the court reporter at least 2 business days in advance. Many times you don't dispute the authenticity or the or that it's admissible, and but if you really do, I mean, and so if you don't really dispute it, we shouldn't have to spend a lot of our time doing that. But if you really do dispute it, of course you can reserve that for trial.
Okay.
All right. So I'm curious, Ms. Salazar, what would be the reason for a sex offender to be living with the children?
So the sex offender is my client's paramour. They're not living together. I want that to be very clear. There's no intention of him to live there. He does have permission from his, I believe, his probation officer to be around children as long as he is supervised. And my client wants to make sure that's presented to the court. We have presented that to opposing counsel. But her client is still, it does not agree for that man to be around the children, but she is not asking for him to live there.
Okay. All
Your
right.
Honor, if I may, and I think that that's one of the issues that's in contention, is that there is a large piece of land with a house, and this man is living in a mobile home, or was living in a mobile home on that same property. So whether or not they're living together, he has access in and out of the house. So it's a little bit deceiving. When we brought this suit to court, I think it surprised mother that either she was unaware that he was a registered sex offender, or she was maintaining supervision of her children while he was around. But since we established this court case, he moved off of the property. And I think what they're trying to do is have him move back into that trailer house that's on the same property as the house.
Of course, you know that the answer to most questions is it depends. And so, Ms. Salazar, you're saying that he has a probation officer or parole officer?
Parole officer, my apologies.
Okay. And so there was a conviction, and is it related to why he is a registered sex offender? It's that he's on parole for now?
Yes, Your Honor, for a federal offense.
Okay. And y'all are introducing that conviction? So that we would know. Okay. Has there been a risk assessment done? Many times there's a risk assessment, a sex offender risk assessment.
I do not believe so. I don't think so. I've been in contact with the parole officer, and I haven't received that information from him. No.
Okay. So one of the reasons I'm asking is because, I mean, we've dealt with, for instance, if you've gone to the Texas Juvenile Justice Department as a juvenile offender, they have to do a risk assessment. They have to notify the court. We're going to want to know, well, and of course, sometimes if you are a juvenile and there are sexual contact with some other juvenile, it doesn't always mean that you are a pedophile, right? And then there are different kinds, there are different things that people are attracted to. It just seemed to me that it might be important that some professional third person has had some sort of assessment with him so we could know, like for instance, someone who was 22 and had illegal sexual contact with a 15-year-old girl could be a registered sex offender, but isn't attracted to same-sex children, not attracted to prepubescent children. Sometimes they are. You know, it would be that kind of thing might be something, and then you kind of can match that to to this circumstance. Who is this offender, and who are these children, right? That might seem to be important to me because, yes, it sounds bad, you know, just to, you know, I mean, if we were at the coffee shop and someone said, can you believe my ex is dating a registered sex offender and wants my children around, that initially sounds bad, right? So you would want to find out more, right? So I'm just asking what we have that's more, because initially, you know, it sounds a little shocking. And on the other hand, there are lots and lots of stories, and whatever the truth of this is, we'll get to. I was just wondering if that's something that anybody had so that we could know exactly, maybe not exactly, we could know more about what the specific circumstances of this person is and how it might relate to these children. Another question I might have is, now, what are the ages of the children? 14 and 11. What are the ages of the children? I looked it up, but I don't recall.
I don't either, Judge. I didn't prepare for a hearing per se, but I thought this was just a waiving of mediation.
Well, no, when we set it for a status hearing, I want to know how, what we're talking about is not because I'm going to use this as evidence. I'm not. But I do want to help narrow the issues. And so there is a little bit of talking about facts that we might have to do. I'm wondering, and so if let me go back to square one. Under our old docket, under pre-COVID days, we let anybody set a hearing for 2 hours. And then we started out with these at 9, everything was set at 9 o'clock, and everybody was expected to be there. We might have started a few minutes late for a little grace period, but then we took up agreements and shorter hearings and worked into the longer hearings. But with COVID, and now that we're doing so much by Zoom, instead of making you sit around in a waiting room possibly all day, we want to give you a specific time. And outside of maybe some cases running long that we didn't anticipate, because of sometimes it's just some difficulties with people's Zoom, or, you know, they've gone a little longer and we wanted to hear a complete case. We just really want to set, so for instance, yours might be set at 9, it might be set at 2, it might be, depending on when we give you the setting, and to try to respect your time that might not make you sit around in a waiting room all day. So that's why we're having these status hearings, so that we can give a better idea. Do you really need 3 hours? Because if you do, you know, we can't do any overbooking, right? Whereas we could set 10 or 12 hours at 9 o'clock if we're all in the courtroom, and expect that something that may be 30 minutes, it takes a 5-minute agreement. And so therefore you could overbook a little bit. With Zoom, if we're not making you wait in the waiting room all day, then we really need to be a lot more clear on how much time somebody really needs. And that's why we're having these. Plus, with the difficulty of introducing evidence, I really want to streamline it so that we really aren't spending a lot of extra time on documents that everybody agrees are just not objectionable. Plus, it saves you the time and expense of going and getting those in some more formal admissible form when nobody really disputes it. So that was my point. So let me now say about the children. One of the pertinent questions would be, what kind of sex offender is this person? What is he alleged to have done? What's his risk? And then who are these children? Do they match up at all to something he's attracted to? How do they feel? Have they been around him? How do they feel about their safety around him? That might be a concern. I'm not saying you have to call a child as a witness. I'm certainly not saying that. But I wanted to bring it up in case someone did. And if Zoom, it's a little easier for a child, rather than having a child in a courtroom in that kind of scary setting. They might not feel uncomfortable at all on a computer screen, right? So I'm gonna, and obviously the older child is, how that person feels may have some more weight for protection than, and it may be that an older child doesn't feel as at risk and a younger child does. Maybe there's a creepy factor somebody wants to testify to. It's the child may want to be heard from. So my question is there also, do you think it would be helpful if we appointed a guardian ad litem to represent the best interests of these children?
I think father has concerns based on the fact that the children are mostly with the mother. Initially, he had best interest of the children concerns because he didn't have access to them. And so he wasn't quite sure if they were repeating what mother said or if they really didn't have concerns about this man. So that would be something my client would be interested in.
Ms. Salazar?
And I think from the conversations I have had with my client, she doesn't see the need necessarily, not that we're opposed to it, but she doesn't see the need just because if my quick math is correct, the oldest child is 16, the youngest is 10. She does feel that they both have an ability to express themselves, and co-counsel or opposing counsel can correct me if my math was wrong, but we're not opposed to it necessarily.
Let me do this. I'm going to appoint a guardian ad litem, and then after the guardian ad litem has gotten involved in, so that the children can be heard from, it may be that we would discharge the guardian ad litem before the final trial. But I think at least that they've been talked to and by somebody separate, someone who doesn't have an agenda and can find out how they feel. I'm going to go ahead and do that. So look, I can certainly sympathize with the idea that we need extra time if there's with the interpreter. That does take extra time. That's certainly a legitimate thought. So I will give you, I'm inclined to give you 3 hours, but let me say how, let's say how we ought to proceed first. Let's get the guardian ad litem on. Let's find out if the guardian ad litem wants to make some representation about it. Then that doesn't mean that's the end of the thing, because children may not feel any fear when they should. Maybe that, I don't know. Like I said, there's a lot of I don't knows, and it depends. So, but let's get that person involved. Would y'all go ahead and now already exchange financial information? Obviously, what is the amount of child support now?
I think it's like $300.
Okay.
I was under the understanding it was 250, but I will double check right now.
Okay. Are there other children? Does dad have other children besides these?
No, sir.
Okay. So you're looking at 25%?
Yes, sir.
Okay. Is there health insurance?
I think that they're receiving benefits from the state. So at some point we need to get the Attorney General involved.
Okay. All right. So can y'all go ahead and initiate that?
Yes, Your Honor.
Okay. And then obviously you're looking at a threshold of minimum wage, 25%. That may have some impact on this. So, okay. So how long will it take for y'all to exchange your documents with the request for stipulation?
I had difficulty communicating with my client this morning, just based on the inclement weather of last week, the tail end of that. So I would need maybe a couple of weeks in order to get that information from him so I can meet with him in person.
Okay. So if I gave you 3 weeks,
okay,
that you could have that and have it to the other side with all the exhibits marked, doesn't mean you're required to introduce them. Just any document you may seek to introduce would be marked, sent to the other side. Ms. Salazar, can you independently send those, any you may have to Ms. Barrera? You don't have to wait till you get hers to then send yours. You can independently send yours at the same time?
Yes, I can. My only concern, or I'm sorry, we're just talking about the documents. Never mind.
Yes. And then during that time, working independently, the guardian ad litem will get involved and doesn't really need to so much worry about those, can work independently to determine what, at least if whether or not that person believes there is a recommendation to be made about the best interests of the children. And okay, Ms. Salazar, you said there was something else?
My only concern with the portion exchanging exhibits by that time is that if we get some sort of risk assessment, I just don't know the timeline on that.
Okay, that's a point I do want to address. I just, I don't know, maybe I just kind of thought that if they had gone to a conviction, that they would have done some sort of risk assessment, but they may not have. Is that something y'all would want to enter into an agreement about to have done?
As far as the recommendation of a guardian?
Well, no. Just for information for the court is if some professional believes he is at high risk, or a professional believes he is at low risk. I've been more involved with those risk assessments with juveniles. And every time they come out of TJJD or any other place, they have a risk assessment. I'm just
I think the recommendation of a guardian would alleviate dad's concerns. He's done the research to find out, the extent of the federal charge and the conviction, and we've reached out to the federal parole board, the federal parole officer, in order to find out more information. They haven't been forthcoming. They've only informed us that the information was sent to mom's attorney. And I think Ms. Salazar provided some of that documentation. So, but it's nothing that would satisfy my client to ensure that his children are safe.
Okay. All
And
right. Yes, ma'am.
maybe, Your Honor, I can look into, after this hearing, the parole officer's ability to either suggest someone for a risk assessment, or if one's already been done. And offline, I can speak with Ms. Barrera and see if we can come to an agreement for that to be done.
Okay. All right. So if we are going to have, all right, there's going to be 3 weeks to get those documents to the other side. There's going to need to be then a period of time to stipulate. So you're going to need to be able to look at the documents presented from the other side, stipulate, and then have, I'm assuming y'all don't need me to make an order for you to talk to each other. Sometimes there are lawyers I do have to make orders to do that. But you sound like y'all are reasonable in discussing things with each other. So I won't delve into that. And so if that's the 3 weeks and then a week to do that, we're a month, and then you need some time to prepare for trial. I don't know how long the guardian ad litem would need, but it looks like we're looking at April or May. Does that sound reasonable to y'all?
Yes, Your Honor.
Okay. I'm going to let you independently talk to Jennifer either now or at any time you want to, that she can give you available dates, and then you can see if there's an agreed date that you can have for us to do that. I don't necessarily mind setting it for 3 hours, because basically what you're telling me is it's really a 2-hour hearing that may take 3 hours because of an interpreter. So I'm okay with that. And is there anything else that we needed to address?
My only question was just if the implication is that mediation is waived in this case, or if we're still required.
It is, unless you're requesting longer than that 3-hour request. And I'm not really waiving the mediation. I'm just saying that this 3-hour hearing would probably fit within my 2-hour rule.
Okay, thank you.
Okay, so we will let you know who the guardian ad litem will be, and we'll then proceed accordingly. Is there anything further, Ms. Barrera?
Nothing, Your Honor.
Ms. Salazar?
Yes, Your Honor, just that the guardian ad litem is bilingual, so that if for whatever reason they need to speak with mom or dad, or my client's paramour, that she'll be able to effectively communicate without the assistance of counsel.
Okay, we can do that.
Thank you for your time, Judge.
Okay, thank you. We'll let you know who the guardian ad litem is. This completes the hearing.
Thank you, Judge.